Yeah, that's right. It's Friday. Welcome back to Law and Legitimacy. This is the first actual full work week for many people, given the cascade of holidays and the way Christmas, the New Year felt. So if it felt like it took a long time to get to Friday this week, that's because it did. Here's the good news about Friday. Ready? Finally, the New York State case against Donald Trump is over, and we won't have to take a look at Ichabod Engoron's ugly mug on the screen much longer, or that of his non-comely sidekick, whatever her name is. But there was, of course, a little bit of drama in court yesterday, and I thought I'd try to. We thought we'd try to add a little bit of legal knowledge to your fund of information as you approach the world. Donald Trump wanted to give his own closing argument. And initially, Judge Engoron said he would permit that, and then he revoked that permission, ultimately giving Trump only a few minutes to speak on his own behalf at his counsel's insistence. This raises an interesting question. Do litigants have a right to represent themselves? And the answer, of course, is yes. But the court supervises that right, and there are a number of practical limitations on it. So if you are brought into court as a defendant in a criminal case, that's not a fight you've picked. And you have a right to representation. You also have a right to defend yourself. But that right to defend yourself under the lead case is governed by, of United States versus Ferretta is subject to a court's determination that you're capable of doing that. So if you're just going to get up there and howl at the moon and bark at cars, and you don't have the ability to comprehend the nature of the case against you, the court may not give you permission to represent yourself. It's a difficult balancing act for the court. Clearly, defendants have a right to reject counsel. They have this comes up often in the public defender context where somebody says, this is a government lawyer. I want my own lawyer. I want to represent myself. And the court recognizes that you have a right to a say in your own defense. That right is a little bit more attenuated in a civil context. Now, if you've never had a lawyer and you've been sued and you choose not to get a lawyer, the court isn't going to say, well, default, you don't have a lawyer. The court isn't even going to engage in all that searing and inquiry about how capable you are of representing yourself. The stakes are lower. It's only money, after all, and reputation. It's not liberty and or potentially life. But once you've got a lawyer, there's really no right to hybrid representation. That is to represent yourself and serve as co-counsel with your lawyer. And the reason for that is it creates the potential for confusion. It creates the potential for inefficiency. It creates the potential for an injustice to be done because a jury might get confused. And notice how I tucked that in at the end of that last sentence. A jury might get confused. I think Engoron gave Donald Trump a pretty good appellate issue when he refused to let him make his own closing argument because there is no jury to be confused here. Whether Donald Trump should have asked for a jury trial in this case and didn't, that boat left the harbor so long ago. I don't even see it over the horizon because the earth isn't flat after all. There is a curve to its surface, and the reason you don't see boats isn't because your eyes failed. It's because they go over the curve. They go over the edge where Columbus was afraid he'd slip and fall. But Donald, there was no risk of jury confusion. So the court gave Trump the ability or the right to give his closing argument, and then took it away because why? Because he was afraid Donald Trump was going to tell him off, because he was afraid that Donald Trump was going to engage in tangential reasoning, because he was afraid that Donald Trump was going to use the stage to give a closing argument that was really a political rallying point. I suspect Trump was going to do all of that. And he tried to do it in the 5 minutes the judge gave him. But what were the reasons that Judge Engoron gave for removing permission or revoking permission to give the closing argument? That Trump wouldn't stay on point. Well, what was the danger if Trump didn't stay on point? It wasn't a danger of jury confusion because there was no jury. And it wasn't a danger of the judge getting confused because the judges are presumed to know the law and to follow it. So the only reason that Judge Engoron could have had for silencing Trump in his closing argument was not to want to give him the stage. And is that an abuse of the court's discretion? Does that suggest that the court was more concerned with the stage and the court of public opinion than doing justice and letting a litigant be heard? So, it's an interesting issue. It doesn't often arise. But then again, there aren't many men like Donald Trump in the world who are engaged. Well, maybe there are who are engaged in litigation. More about that later. But I think that in an unwitting sort of way, Judge Engoron just handed Donald Trump a very promising appellate issue, because the court may have abused its discretion in silencing a man who wanted to speak on its own behalf. The reasons given by the judge being totally inapt and inapplicable to the case at bar. But Judge Engoron now has the case. He's promised that he will reach a decision, or he will try to reach a decision by the end of January. At stake is as much as a fine of as much as I think 350 million, and the loss of the right to transact real estate business in New York,
Well,
business of any kind.
I'm compelled by the point you make about the reasons for declining a defendant or a party to a lawsuit, especially in a civil lawsuit like this, the ability to uh, to speak to the jury. Do you have any idea what the standard of review generally is on that issue, or what it would be?
It would be it would be an abuse of discretion, whether the court abused its discretion in refusing to permit him to testify. And so an abusive, discretion, and that's the worst standard for an appellant, for a person bringing an appeal. There are a number of appellate standards. One, clear abusive discretion means the judge has a right to make a decision. You have to show it abused that right. There are things that are called clear error or plain error. That's where something slips by the judge and is so obviously wrong that any competent person reading the law will say, whoops, let's have a do-over. And then there are constitutional errors that are either harmless or not, depending on the circumstances. And so one of the challenges in writing an appellate brief is to identify issues. And would you get that witch off the screen?
I was just trying to give you an illustration of an abuse of discretion.
But one of the
Are we allowed to use pictures in our briefs to the appellate court?
Well, let's talk more about Morticia in a moment. But one of the challenges in appellate law is picking an issue and getting
like a Walmart brand Adams Family portrait here.
It really does look that way. The Adams Family started when Judge Engoron farted. She really is retarded. The Engoron family. Ba-da-da-da, boom, boom, ba-da-da-da, boom, boom. Hi, my name is whatever my name is. Was it Ms. Goldstein? And I'm here to tell you that when the judge doesn't have a thought, I telepathically put one in his head. And you know what it is, Donald? You know what that thought is, Donald, when I put it in there? You suck. And I'm not a judge, but I got to sit on the bench and sit in judgment over you, and you couldn't speak. Ha 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 ha. But guess what? The camera's on me. It's not on you. Ah ha 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 ha. And guess what, Donald? Maybe I'll be the Democratic nominee for president. How would you like that? Ah ha 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 ha. Or maybe I'll be the write-in candidate for the Republicans. Ah ha 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 ha. I'll shut up now. So abuse of discretion means, that no reasonable jurist would have done this. And I think when reasons given for an act are so lame, and so unsupported by any justification, there is a credible claim for abuse of discretion. So let's see what happens. As to the case itself, I'm sure Judge Engoron is going to find against Trump, either in whole or in part. But I'm still compelled by the fact that in this case of fraud, bankers knowingly and willingly lent money to a man who they knew had estimated the value of his properties, and then made money on the loans that they loaned to him. And so I recall once.
Not only that, here, just to support what you're saying right now, this is in this New York Sun article. Mr. Trump pointed out that the Zurich Insurance Group, one of the most prestigious insurance companies in the world, still insures his property. So in addition to the fact that there are no monetary damages being claimed by any of the lenders or banks involved in his projects, insurance companies have held fast, right?
Yeah. Well,
to the relationship.
I remember years ago representing a lawyer in a white collar case, and the claim it was very complicated, but the claim was that he'd somehow defrauded his partner. So we hired a forensic accountant, and we found out that the partner also defrauded our client, and maybe even more. So I called the U.S. attorney who was contemplating charges, and I said, "How are you going to prove a loss amount? And do we get a credit for what what was stolen from us by the alleged victim in this case?" That case evaporated in a nanosecond. But let's move on. Good luck to Donald. Let's see what happens. I was struck, Mike, by a story I saw in Time magazine this week. Headline: Judges in England and Wales given cautious approval to use artificial intelligence in writing legal opinions. And as you pointed out in our discussions prior to coming on the air this morning, John Roberts addressed the issue of AI's increasing role in American courts as well. What's your take on what's going on in England? What is going on in England, and what's your take?
Yeah, so in England, the what's known as the Courts and Tribunals Judiciary last month issued guidance, and I'll pull that up on the screen as well. They issued guidance specifically for judges, right? And here it is. And it's titled Artificial Intelligence Guidance for Judicial Office Holders, and this is December 12th. And the introduction spells out the fact that, that guidance has been developed specifically to empower and assist the judicial officers to actually engage with artificial intelligence in a manner that is, I guess, befitting of the court norm. It's almost as if rather than trying to push back on the use of artificial intelligence, this court or this program here is designed to engage artificial intelligence, embrace what's already out there, and then begin setting standards that reflect a lot of what you and I have talked about in prior cases and instances before. And we can just quickly roll through this. This is a very quick document, but it starts by defining the various iterations of artificial intelligence that are out there for retail use. And then I think it lists about 7 different items here to consider, right? Number one, how AI is like what it is and how it applies. The second is upholding confidentiality and privacy in the risks associated with that, ensuring that the judges, if they use it, are accountable for what they're using and they're accurate, right? And number 4, very closely tied to that, is the acknowledgement that there is existing bias within these large language models that are generating responses based on not a static data set, but obviously fixed data sets, right? They're being fed information and that's sort of that opaque wall that a user doesn't necessarily know about without doing some really deep dive on research, or there's some other reason to trust that the bias is fairly minimal or otherwise, right? It talks about maintaining security within the use of AI, meaning use work devices, use paid subscriptions, be responsible with how you're feeding information into the AI platform, taking responsibility for anything that is actually produced in any of the judicial officers' names, and then being aware that those in front of the court may have used AI tools as well, and impress upon those users of AI their co-equal obligations as already set forth in this document, right? And that includes holding them responsible for violations of their ethical ethical or unethical conduct in that regard.
Here, I'm surprised that the courts encouraged the use of AI. I'm still very skeptical of them because it eliminates the human factor in making judgments, which is the quintessential function of being a judge, I presume. And here's what I'm worried about. I'm worried about outliers, and I'm worried about the use of large language models. To the degree that I understand AI, and that's not 100% guaranteed that I do. The use of large language models means that what a machine is able to do is to discern patterns. And if you set this device loose on a large enough set of data, it will go through that data and identify those patterns. And those patterns, in effect, are sort of like the common law. In other words, if an expression gets used often enough, it becomes a center of gravity. And when words get associated in certain ways, they can point toward a center of gravity. And so if I say the cow jumped over the moon, that might go to the class of poetic fiction's utter nonsense. It's unlikely to go toward accurate astronomical predictions. And so these centers in the common law, folks, those are a set of rules of thumb that courts have used in resolving the ordinary disputes that come before them. And they become doctrines when enough judges accept them, and they prove their use in the marketplace of litigation. The rule, I was going to say the rule against perpetuities, but I don't want to have to try to explain it. It's been a long time since I took the course. but offer in consideration in contracts. So these are common law doctrines. In order to have a contract, there must be a meeting of minds. You have to make an offer. There has to be acceptance. What's offered is consideration. What's accepted is the consideration. There are mutual promises. And all of this stuff is steeped in the historic architecture of cases over centuries. And there are rules of thumb that judges can use when they recognize this is a contract case. I know now what to look for. The secret of a legal education is not that you know the answer to every question, but you know what questions matter. And you know how to find answers based on pattern recognition. This is what's called a hypothetical. This is why a law school education is based largely on examination of hypothetical cases. The test of lawyering is your ability to recognize patterns and your creative ability to manipulate legal doctrines on behalf of your client's interest. But listen to what I've not talked about. What do we end up with in the common law, and what do we end up with in large language models? We end up with tendencies. We end up with bell-shaped curves. There's a center of gravity, and most cases come to the following point around a certain conclusion. But in every bell-shaped curve, there are tails at the other end that are no less true, that are no less real. They're just not reasonable, or they're not common. And so my fear about AI is, to the degree that judges use artificial intelligence and large language models to help flush out patterns, they'll be forced into the center of the bell-shaped curve, and people at the tails will suffer. What do I mean by that? For example, what is the effect of a person giving a statement under oath? Obviously it binds the person. That's an admission that a person is going to be held to. What if the person lied under oath? Well, that lie will hold against them in credibility, and a person or a entity can hold that against them. A liar's credibility is diminished, and so an algorithm might weight less what that person said. Hypothetical. What if it's all true, though? I had a case many years ago that proves this point. It was a so-called tennis shoe murder case. My client was involved in a street-level transaction. A shot was fired, and somebody was struck in the back of the head and killed. My client didn't know that anybody had been shot, that had been killed. It was fired into the dark. Police arrived at his home the next day. Were you at the location? Yes. Did you fire a shot? Yeah. Why? I fired a warning shot. They got him to sign the confession, then told him the guy was dead. By many lawyers' rights, that man had just confessed to murder, and his only sensible option would have been a plea bargain. The fact is, he did lie to the police. He lied to the police because he was afraid if he told them the truth, his uncle, who fired the shot, who he didn't acknowledge was at the scene, would be convicted of felon in possession of a firearm, and he was trying to protect his uncle. So we took that case to trial, and we had the client get on the witness stand and admit that he lied. We had other witnesses get on the stand and say that he had a reputation for truthfulness in the community, notwithstanding the lie. The jury acquitted him of murder and every related homicide charge, and he walked out the door. That was a case where the tail governed, because in the courtroom, jurors made the quintessentially human decision about what to believe. Would that case have gotten to trial if AI or algorithms controlled any part of that route? And wasn't the client, I don't want to name, well, I think it's been all over the press, wasn't Mr. Gibbs, the client, wasn't he entitled to go to a jury, and wasn't he entitled to get a human evaluation of his credibility? AI can't do that. I don't think. It doesn't have that human spark of recognition. And so I'm deeply troubled by Britain's willingness to permit judges to experiment with this, because I think that what we pay a judge for is to make judgments. And as we talked about
you sound like a Chief Justice of the Supreme Court. What I have on the screen, just to support what you're saying, Norm, but also point out to you that I don't think that you're speaking in isolation. This is Chief Justice John Roberts' 2023 year-end report. This is referenced in the Time article, and I pulled it up just to read, to see where he was going with it. Most of this is a sort of a historical perspective and chronological move forward.
Somebody had fun writing that for him.
Yeah, right. They went on a deep dive of the print.
It's a fun read.
But he says, quote, "Machines cannot fully replace key actors in court. Judges, for example, measure the sincerity of a defendant's allocution at sentencing Nuance matters. Much can turn on shaking hand, a quivering voice, a change of inflection, a beat of sweat, a moment's hesitation, a fleeting break in eye contact. And most people still trust humans more than machines to perceive and draw the right inferences from these cues. Appellate judges, too, perform quintessentially human functions. Many appellate decisions turn on whether a lower court has abused its discretion, a standard that by its nature involves fact specific gray areas. Others focus on open questions about how the law should develop in new areas. AI is based largely on existing information, which can inform but cannot make such decisions, but not make such decisions.
Yeah, and so the line is it's difficult. We're there. There's going to cut there. There is a line there between large language, what a machine can do, and what a human must do. And I hope that, and I suspect the English judges are mindful of that clearly. But I have my doubts that AI is necessarily going to be the breakthrough technology that transforms the legal profession. I certainly don't think lawyers should be replaced by it because in the end, you're always making judgments about things you see, and in the end, there is no replacement of the difficult discussion that a client and lawyer have to have before a big decision gets made. I'm going to give you a case in point right now. We're going to try something a little different here on the podcast. We're going to take a tale into the crypt, a tale from the dark side. Now that I'm wandering around the courts again in Connecticut, and people are like, "Where have you been?" Well, I get my ass kicked in the Alex Jones case down in D.C. doing War on the Proud Boys. Before that, involving a case that consumed a lot of time and a client who committed suicide. And now I'm back to the ordinary practice of law: murder, robbery, rape, mayhem, the sort of things that a criminal defense lawyer does. And candidly, I'm enjoying it. I am enjoying the human contact with people in extraordinary stress, often in extraordinary circumstances, who must make life changing decisions in the face of uncertainty. And what I can bring to that discussion is decades of experience and an assessment of how this chaos is likely to unfold in their life. So let me give you a hypothetical case, with some of the facts altered ever so slightly, but this is the essence of the case. Couple observed at a casino in Connecticut. Older man, younger woman, flushed with cash. They leave the casino, get into the man's car, drive an hour or so away to the old man's home. Turns out the young woman is a woman of the night, a hooker, and the guy's having the time of his life until there's a bang on the door at the home. Young man followed them from the casino, saw the cash. It's a home invasion. There's some violence in the home, and the hooker ends up being raped by the man entering the home. And at the end of the evening, the old man's been brutalized, and there is semen on the woman's face, and she's stunned. Police get a description of the man. They go to his home with a warrant at some point, and he's hidden in a crawl space in the wall. They have to pry him out. They find out he's the guy they're looking for, and in the house there are all this drugs and guns. And you're thinking, huh? You're happy to be back at that? Well, life happens, and stick that into an algorithm, and what you're going to do, you're going to melt the computer's wires, and the thing's going to start to shake. So what happens in this case? He faces 80 years or so in prison for the home invasion, decades for the conduct in the other city when he was arrested. But the state has to evaluate what evidence is admissible now, and what it can prove to a jury. So the old man died several days after the home invasion. Maybe it was a result of the stress of the home invasion. Nobody knows. Our client hasn't been charged with causing his murder because I think it would be impossible to prove, or his death rather, because I think it would be impossible to prove that he caused the death. But here's the rub: whatever the man told the police is hearsay, and it's not admissible in a courtroom. So that witness is unavailable, and that evidence is unavailable. Now you've got a hooker with semen on her face. Well, that might either be a result of a crime or an occupational hazard. Suppose she's reluctant to come to court to testify, or the state can't find her. Can the state prove anything about what went on in that house? They can prove that the young man was there. They can prove by identifying his DNA that an occupant of the home had his DNA on him and they retrieved it. But absent any other testimony, there's not much of a case there. So then you go to the case involving the apprehension of him in his home, and he's reluctant to come out of the crawl space in the wall. Well, that looks like consciousness of guilt. And the officers find guns and drugs within his home. That's an area within his dominion and control. Realistically, he's going to be convicted there. He's got a criminal record, so he's probably looking at 10 years on that at a minimum. So now the question becomes, what do we do? He's a young man. He doesn't want to be in trial. He doesn't want to be in jail. He's in jail in lieu of a high bond. And the state has to make a realistic assessment of its evidence and make him an offer if he's, unless it decides to go to trial. And 90+% of cases resolved by way of plea. So they offer him 12 years. Our position is that's too much. We get him down to 10, and now the young man has a decision to make. Our recommendation is that he take a plea in that realm, because whatever happens, the conduct in the house where the drugs and guns were found are likely to result in a conviction, whereas whatever happens in the house, whatever happens to the case in the house, depends on whether the prostitute turns up. If she turns up and can corroborate a tale of violence, she may be believed. On the other hand, she's open to impeachment because an occupational hazard of prostitution is exposure to semen. So, can she testify without her occupation and what she was doing that night actually coming into the question? And would that create reasonable doubts in the juror's mind? I tell you this story, it's real enough. Some of the identifying details are obscured to protect privacy and so forth. But this is the reality of our criminal justice system, and it's the reality of plea bargaining. In the folklore, everyone goes to trial, and trial is this dramatic confrontation of two sides wherein truth is ultimately exposed or comes to light. And the fact of the matter is, we rarely get the whole truth and nothing but the truth in a courtroom. What you get are approximations, and you get approximations based on what's available in terms of evidence. And sometimes the evidence is infirm, and sometimes evidence disappears and dies. Yesterday, a client of mine was sentenced to 10 years after being charged with murder. What happened is most of the witnesses against him died during COVID. That was a break that we didn't plan, but it was a break that we exploited. And so rather than going to trial with one very shaky witness and facing 60 years, he accepted 10. And it was an acceptable risk. From a lawyering perspective, those discussions take place one-on-one. And you have to be a mirror to the client, holding up what you see in the evidence so they can see it for themselves. And then you have to explain to them what's likely to happen in the course of a trial. If a witness turns up, what factors will a jury consider in its credibility determinations? What's reasonable for reasonable people to believe? And then you present your recommendation to the client based on your assessment of the file, and the client makes a choice.
Norm, can you stay on the mic? Yeah.
Yeah. So that's life in the law, folks. It's a tale from the crypt. It may or may not be of interest to you. It's not in the headlines, but every day in every criminal courthouse in the United States, these are the sort of realistic discussions that go on, and they result in plea bargains that are placed on the record in open court. I noticed yesterday when my client was sentenced to 10 years in the case that started as a murder and ended as a manslaughter, the family was complaining bitterly in the pre-sentence report. He hired a high-profile lawyer. He would have gotten more time if he had a public defender. No, in 99% of cases, the lawyer doesn't matter. Cases work themselves out based on the evidence and realistic assessments of the odds. So it's hard work, it's necessary work, and it's work, Mike, that computers just can't do. And when I see these stories about AI, they can identify legal doctrines, but putting those doctrines into practice, making assessments about risk in the shadow of the law, advising clients about whether to roll the dice at trial or minimize the potential harm to themselves by pleading. That's the law, and that's lawyering.
Dawn asks the question, do most defense attorneys like to go to trial where they have to make arguments, etc., or do they prefer a plea deal? Is this a variable in the decisions?
It's not supposed to ever be about the lawyer, Dawn, but I suspect it always is at some level. So I prefer trial because trial is fun. It's three-dimensional chess, and it's a test of wits. And I like my odds in any contest of that sort. I like to joke, 5 lawyers on the other side, that's about right. I'm ready. I like my odds. I had a case involving 5 or 6 lawyers not long ago. It was all over the press, and at one point they pulled me into the hall we need to work this out. You're making us look bad. I said, that's what I'm here for. Stop complaining that you're just feeding the fire. So I think the most effective way for a lawyer to prepare a case, as we do in our office, is you prepare every case as though it's going to trial. And then the state, or even on the civil side, knows you're serious and you'll get better offers. But in the end, the decision about whether to go to trial or not belongs to the client. Years ago, I had a horrible case where my client was observed throwing his 7-month-old son off a bridge, the highest bridge in the state, 100 feet into the water, where the child died. The client then jumped in and survived. That's a hard case. I mean, I got death threats over that. My car was keyed in the courthouse parking lot. People still malign me for that from time to time. In fact, if any of my haters are watching this, I'll probably get emails today. You scumbag. And so the state was outraged by the behavior. And it is outrageous. And their plea offer was 50 years. 50. Wow. So plead guilty and you can go to prison for 50 years. And I was outraged. That's not a plea offer. That's, he's not going to do much worse than that if he went to trial. We went to trial and lost because the client insisted that he would not take the plea. So it's an adversarial system. I like to use the following metaphor with clients. In a criminal case, you've been tied to a train track, and that rumbling you feel and that sound you hear is an engine coming toward you. And my job as your lawyer is to get as much of your body off the tracks as I can before the engine arrives. If we can't make a decision, you're going to get run over. And, sometimes the client can't make a decision. And if they can't take the plea or we can't resolve it, the case gets tried and sometimes they get run over. And a lawyer's job is to work as hard as they can to prevent that from happening.
Don follows up, and then we'll close out. Does law school prepare lawyers to be good public speakers, persuaders, etc.?
I don't know what law school does. I mean, to be honest with you, Dawn, I didn't go to class all that much. It was kind of a waste of time. Law professors are failed philosophers, failed sociologists, and failed economists. They take legal doctrines and they like to talk about the theories that infuse them. The law isn't driven by theories. The law is driven by a client's interest in pragmatic assessments of what you can do to help your client. So I don't trust law schools. There are legal clinic programs in some schools. There aren't public school speaking classes and whatnot. I think you learn to persuade by being persuasive. I mean, when I first walked into a court, my very first criminal case, I'd passed the bar. I was associate of a very renowned lawyer in Connecticut. He handed me a file. He says, "You're going to criminal trial." 2 days afterward, and it involved firearms in a house. It did, actually. And I looked at the warrant and I said, this can't be right. Cops had no authority to be in that. Hey, it was a multifamily home. They went into the second floor. They didn't describe with particularity the place to be searched. Then, was it the first or second? So I pointed it out to the prosecutor. I said, how are you going to prove that this is a lawful search? He says, well, I never, nobody ever pointed that out. Well, I said, well, I am. And so we did a little, found out they had separate utility bills and whatnot. So he dropped the case. He nollied it because the evidence was obtained unlawfully. And I wanted the case dismissed. So I ran out into the hall. This was in the days before cell phones. And I called my boss and I said, great news. The case was nollied. How do I get it dismissed? He said, you have to ask the judge. You have to move for a dismissal. So I went back in the courtroom and I moved for dismissal. Well, that taught me everything I needed to know about persuasion. If you can imagine it, ask for it. If you can't get it, the other side will tell you why. And then you've learned a little bit of law to use in the next case.
So Don, you followed up by saying, I assume not. And I don't, I caution you to take that away from what Norm just said. Two things to offer here. One, law school does offer technical foundations in legal research, objective brief writing, and then after objective brief writing, persuasive brief writing. There are also, exams geared toward oral argumentation. There are all sorts of opportunities for moot court and law review. So if a particular student desires to hone those skills, the opportunities are available. The second thing I want to say, Norm, is that professors with experience akin to yours are the best guarantee that a student will get those skills by and through their doctrinal coursework. I say that because my law school did not have a reputation a la the Ivy League or any of the first tier law schools here in the great state of North Carolina, Duke, UNC among them, Wake Forest as well. We were not on that reputational or pedigree tier. What we had was a slate, a stable of well-practiced, well-experienced attorneys, those that had brought entire franchises to the city of Charlotte, those that had represented massive Fortune 100 companies in their, in their adversarial proceedings in civil court. We had those who had represented criminal defendants in white-collar contexts, right? And those were the ones who could enliven the text and the subject matter of these courses. So, yes. However, I think that what Norm is making a nod to is there has to be some desire, some ambition, and some go-get-itness on the part of those who want to be lawyers, right? Norm being in there and then getting on the phone, I just think that's so funny. The image of a young you get on a payphone in the hallway of a court asking your superior, like, I won, but what do I do?
What do I do?
It's beautiful, right? Because I've run into those moments in my young career. I've sort of outkicked my coverage, so to speak, right? And what do you do in those moments? Is like, just to finish it out and follow through. I think that law school still can prepare, but it takes two willing parties at a very minimum, right? And so I wouldn't say that there's a static no. We can, kind of refer back to the general state of big education right now, and the lack of any sort of connection between what a real education is and what's being sold to students. But I don't think that that's the appropriate way to answer your question. I think that what Norm and I aspire to is to at least be an ambassador and a symbol that the answer to your question is and will always be yes.
So, Mike, can you put on our webpage the article we talked about earlier, the Revolt of the Kids by the American Mind? I finally had a chance to read through it carefully since the other day when we talked about it. A not altogether uncommon phenomena here. Let's spot something, talk about it, and then read it. This goes to Mike.
That's law school in a nutshell as well, by the way. Did you brief this case? No, and then you get embarrassed, and it's like, shit, I should go and read that.
I think it's life in a nutshell. I mean, but it sort of goes to the point Mike was making about the failures of education, but it also goes to attitude. And Dawn, you'll particularly appreciate the Revolt of the Kids. It's by Inez Felcher Stepman. It's about differing attitudes in age cohorts, and I know that Dawn is a sociologist, and how these various age cohorts have fundamentally different attitudes about different issues in world politics. What's so depressing about the article is it doesn't ever talk about aspiring to be more than the sum of your attitudes, to challenge those attitudes and to come to some intergenerational agreement about what is good, what is just, what is reasonable. But I'd encourage folks to read it. I'm going to spend a lot more time thinking about generational cohorts. Mike keeps raising that point, and there is something fundamental going on in the world, and I think our educational system needs to address it.
1,000%. This weekend, Norm, our subscriber threshold has been raised by the Beehive gods. So the newsletter is ready to go out. So that'll go out tomorrow morning, Saturday, January 13th, as well as at least 2 essays that you've had laying in wait. And if I am particularly productive, no promises, we also have a long form interview that we did with one Pete Atkinson that we will be publishing as well. And I want to embed those on the website rather than just publishing the audio only via the normal podcast feed. So we may just exclusively harbor those on the webpage just to encourage you all to visit the webpage, to join the newsletter, and to always come back here, right? You always ask me this question. So where else may I find
before a shout out to Maury. I haven't seen Maury here today. I got a nice note from Maury last night after I talked about stand-up comedy and whatnot. Maury is an actor, stand-up comic, writer, and performer extraordinaire.
That's awesome.
Who's by the name Maury because the dog that I don't want to even reveal Maury's gender because I don't have permission. The dog, so the dog is, and I can't remember Maury. I can't remember from the email. It's a senior moment. Maury, you'll appreciate that, I suspect. Anyhow, shout out to Maury. Thanks for the reach out. I appreciate it. Mike, how do people find us?
We're live every day every weekday, that is, here on X at LawPod Daily. We're also on YouTube at the same handle at LawPod Daily, and on Rumble, but only called Law and Legitimacy on Rumble because they won't allow me to change the name, I guess. I don't know. Anyway, every weekday morning, 8 a.m. live, and we're also found on wherever you find premium podcasts: Spotify, Google Play, Apple Podcasts, Audible, Overcast, wherever. The audio only version every day right after the stream wraps up. Go to lawandlegitimacy.com again, or LawPod Daily. And we also have lawandlegitimacy.com. I'll get that linked up. But got to finish the website. The newsletter will be going out. That'll come directly to your inboxes. Thank you for. We've had a surge of interest in this newsletter, so I'm optimistic about that. I love having the ability to connect with you all more directly and have a little more flexibility with the way that we deliver content to you. So Norm, thank you for this week. I think this has been a really, really productive week, a nice change of pace. I feel great just, being frank here about stepping back from what we've kind of coined together, the digital rage machine, right? That socio-cultural impulse that we have right now to chase the news. I know that there's a lot going on and plenty of urgent, emergent items that people want to talk about and hear, and there's plenty that'll do that. But I love kind of getting into this pocket, staying patient with some of these topics, and exploring when we have the opportunity things like artificial intelligence and the law, the evolution of law school, those kinds of things. So anyway, thank you, and we will see everybody on Monday morning, bright and early, 8 a.m. Norm.
Great weekend. Stay dry, safe, and warm. The weatherman tells me that'll be a challenge this weekend.
See y'all later. Bye.